So I could start off by talking at some length about how terrific this paper is, but that would eat into my own time. So just consider it said. It is. As I read the paper, it makes three main claims. I agree with two of them and disagree with one of them. Let me explain all three. So the first claim is that constitutions in general can be and should be understood as acts of lawmaking. I think this is right. That is one way of understanding constitutions is as superior laws. Yes, constitutions are typically supreme, but it's also the case that acts of Congress are supreme over administrative regulations. So if we understand a constitution as in some way supreme over other laws, there's nothing about that fact that automatically removes it from thinking about it as lawmaking. Yes, there are issues that Richard explores about whether we want to consider the lawmakers as the drafters or the ratifiers or some number of others, but basically the idea that a constitution emerges out of what we can consider as or conceptualize as a lawmaking act strikes me as right. Second, and perhaps this is the mirror image of that, if it is a fact that constitutions can be considered as lawmaking acts, then the mirror image is that what we might think of as ordinary laws can and frequently do have constitutional status. Here, once again, the idea of a rule of recognition or the ultimate rule of recognition or a Hardian view about all of this comes into force. Once we recognize that the ultimate rule of recognition is not a matter of validity but just a matter of fact, then we can say that it is open to a polity to recognize this or that as its law, and a polity to recognize this or that as its constitution or as part of its constitution. So, yes, there is this thing that sits behind however many inches of glass at the National Archives that we happen to have recognized as our Constitution, as part of this act of recognition. But it is also the case that we may have recognized some number of other things in the United States as part of our Constitution as well. It's possible that in important ways, the Federalist Papers are part of the Constitution. It's possible that in important ways, Brown versus the Board of Education is part of our Constitution. As Judge Arnold in the short-lived Anastasoff case of about 10 years ago recognized maybe the whole idea of the common law is part of our Constitution. There is nothing about the idea of a Constitution that has to limit it to the thing that sits behind the glass at the National Archives. Indeed, although Richard noted carefully that he has never lived in a country with a capital C constitution. He's always lived in countries with small c constitutions. Just as we can recognize things other than the document behind the glass as the part of the Constitution, so too in the United Kingdom has it been recognized that Magna Carta, the Bill of Rights of 1689, possibly the principles of natural justice are part of the Constitution. In Richard's own country, I gather that it is either argued or taken for granted that the Treaty of Waitangi of 1842, plus or minus,
Minus 2, 1840.
Has constitutional status. And once we recognize all of this, then there's no reason that things that might on their surface look like ordinary statutes or ordinary law become part of the Constitution. So in that sense, the Constitution might be understood as the document behind the glass, plus or minus, and the plus could very well include some forms of ordinary legislation. All of this is well developed by Richard. All of this, it seems to me, is right. But what follows from the fact that we think about the Constitution, or can think about the Constitution, as a lawmaking act. At least for Richard, one of the things that flows from that is that we ought to understand the Constitution, or for that matter, lawmaking in general. We ought to understand any act of lawmaking on, broadly speaking, a command model, such that the lawmakers are giving commands or instructions that we are trying to follow, and in order to follow them, just as those of us who've been privates in the Army try to follow the sergeants and the lieutenants, we should try to figure out what the lawmakers want to do and therefore follow it. Maybe. At least I want to suggest in a few minutes that in lots of forms of life, we hold people, and lawmakers are people, but we hold people to the consequences of their acts, regardless of what they may or may not have intended or willed or commanded or anything else. Call it the you break it, you own it principle of legislative interpretation. Things that people do produce consequences, even if those are not the consequences they intended, even if those are not the actions that they wanted to take. Moreover, this happens with some frequency when the things that people do involve the use of words. One example comes from the common law of defamation. In the common law of defamation, it has been understood for literally centuries that people are responsible for the ordinary meaning, call it public meaning in this group, the ordinary meaning of the words that they use, even if they intended to say something else. That the mere fact of using words doesn't necessarily mean that the user's intention in using those words will be dispositive about legal consequences. Another example comes, as Richard mentions, from the idea of precedent. So in Richard's paper, he talks about the fact that Cass Sunstein has mentioned on occasion that when we interpret precedent, when we interpret the law that is precedent, we rarely look to the intentions or goals or commands of the actual people who have created the precedent. Yes, there are large debates, and have been debates for some time, about just what it is that a precedent stands for. There's a relatively recent debate, for example, between Larry and Grant LeMond about how we should understand what it is that a precedent stands for. If we go back a generation, there were debates among Brian Simpson and a man named Montrose and Arthur Goodhart about just what it is that a precedent stands for. So yes, these debates exist. Nevertheless, it is a common part of actual legal practice that we take what exists in a precedent, we take the court's words as having importance, independent significance, without regard to the mental states of the judges or courts who have actually produced the precedent. Indeed, although what I have just said is an assertion, there's an interesting paper that came out a couple of years ago by my political science colleague, David Klein at the University of Virginia, and Neil Devens at William & Mary, documenting empirically the way in which actual words in precedents have a much more important significance than we might think, and that although we can engage in nice debates about holding, dicta, ratio decidendi, and everything else, it is most often the case that what a precedent court says is relied upon by some number of other and subsequent courts. As a result, it is a common part of actual legal practice that we don't use a precedent court's intentions. We don't think of the precedent court as giving us instructions that we must follow based on what we think they had in mind. And indeed, although Richard uses Cass Sunstein's chapter as an example of this, the argument goes back a little bit earlier in an important but too often neglected article by Adrian Vermeule, and much more recently in an article in the University of Chicago Law Review by my colleague Charles Barzin, all exploring the anomaly of the fact that there is very little discussion in, broadly speaking, originalist discourse about original public meaning of precedents, or about intentions with respect to precedents and so on. So although it is true, as Richard says, that Sunstein's example is underdeveloped, there is a difference between underdeveloped and wrong. And I would want to say that although it may be underdeveloped by Sunstein, the idea of precedent is an important example of a lawmaking act in which intentions or commands are not particularly important. If that's right, that suggests that we could have an understanding of lawmaking that is not tethered to intention and that holds legislatures responsible for what they say and not what they intend to do. Some of the work of Einar Elhage is consistent with this, and various others. Richard does develop the idea and the normative argument for taking the intentions more seriously than I have given him credit for, but I say what I am saying now only to suggest that it's not inevitable. There is a plausible and serious alternative out there, and not only do we have to develop the argument, or not only does someone with Richard's conclusions have to develop the arguments about why we should take seriously what it is a legislature or a constitution maker as lawmaker wants to do, but why we shouldn't instead consider this just one more example of the you break it, you bought it theory, and you are responsible for what you have done regardless of what you may have intended.
So Richard, you got a couple of minutes here?
Okay, right. Well, I want to disagree with one point of Fred's agreement and agree with his point of disagreement. So here we go, in part. So only in part. Thank you for those extremely helpful and penetrating comments. So your second point about how ordinary laws can constitute states. Obviously, I don't disagree with that. My worry with the comment or the larger claim was the suggestion, I think, that there's a rule of recognition that determines what the Constitution is, Constitution small c. Now, I suppose that's possible. It could be a kind of practice that has that structure. I don't think it is, though. I think legal systems have that structure, certainly. There's a rule of recognition that marks out, we use to identify the bounds of the system. Law is systematic in that way. Law has nice, sharp, pronounced edges in that way. The Constitution, though, I don't think does, partly because the Constitution consists in propositions that are not law, but of course you could have a rule of recognition that defined and recognised propositions that weren't legal propositions, because here we were talking about the Constitution rather than the legal system. But I don't think that's what we have in the places where we have, which is a lot of places, small c constitutions. Certainly I don't recognise, as an Anglo-New Zealand lawyer and a sometimes observer of American practice, I don't recognise us as deploying a rule of recognition that identifies certain propositions as constitutional in that way. So particular norms and conventions that do so much work in the British Constitution, in one sense, are ad hoc. And they have a connection to one another. They have an intelligibility that makes them hang together. So they're not, maybe in the end, ad hoc. But I don't think they're systematic in the way that a rule of recognition makes law systematic. Now, in relation to the third point, so Fred's point of disagreement, I certainly don't want to claim that all lawmaking is an intentional exercise of authority. I don't think precedent is an intentional exercise of authority. I don't think lawmaking by precedent is an exercise of lawmaking authority, in fact. And I know there are a lot of theories of precedent, and to the extent I have one, it's rather underdeveloped, but it seems to me there's a pretty good reason for thinking of precedent as law that's made as a side effect, as a consequence of an act, the primary purpose of which is adjudication. It's such that the court doesn't actually control the lawmaking consequence of its action, even a court that purports to. Now, of course, if you're a ruthless and disciplined enough appellate court, by virtue of your decision in relation to a succession of cases, you can exercise a kind of control. But the structure of the common law, it seems to me, is not that. It's a structure whereby the law is made, whereby each decision contributes to the body of material that then finds an explanation, the explanation being the law. It sounds a bit Dawkinian, and probably it is. So I think there's a pretty big difference between lawmaking by side effect of adjudication and lawmaking by legislative action. And my argument about the significance of intention is confined to deliberate lawmaking. Lawmaking, the point of the act, the sole point of the act in one sense, in the matter of law, is to change the law. Now, the you broke it, you own it principle. Well, in one sense I agree, which is that the reasonable inferences we can draw from the public body of evidence as to what was intended are rightly controlling. So we do our best from the evidence we have to figure out what Parliament or Congress intended, or the constitution makers, and that rightly settles the decision before us. It settles what we jointly, the audience, take to have been made law. Now, I'm a bit more sceptical than Fred is about there being a meaningful distinction between what's said and what's intended, even though I acknowledge one could be wrong about what someone's intended, and that you could be stuck with, we could reasonably be stuck with what we reasonably thought was intended but was not. So I'm going to stand by my position, developed elsewhere in more length, that legislating, the mode of lawmaking that is legislating, does centre on intentional action. And even when one's mistaken and the mistake is conclusive, you can't get away from an attempt to understand the exercise of authority, which is making and promulgation of intentions. Probably over 3 minutes, so I should stop there.